Welcome to today's webinar. Before we get started, I want to remind you that the information provided in today's webinar is not intended to be legal advice. We strongly encourage you to seek legal counsel prior to making any significant employment decisions. The written and verbal contents of the presentation is informational to help you determine if you need to take appropriate steps to prevent or stop harassment in the workplace. This information is not limited and is intended to create a consulting relationship, or it's not created any relationship between the presenter and the attendees. If you are listening to this video live as a webinar, then welcome, and you will be participating with us through polling questions and chatting questions, and we'll look forward to your participation. If you are watching this video via YouTube, then I will ask you to pause the video while you grab a piece of paper and number it from 1 to 25 so that you can participate in all of the polling questions and chatting questions that we have throughout the presentation. At the end of the presentation, I will give you some instructions on where to send that information in order to receive your certificate of completion. Again, if you are attending this webinar live, then you don't need to do that. We will be going through the polling questions and chat questions live, and I will be sending your certificate of completion after the presentation today. So, with all of that disclaimer out of the way, let me greet you with a more friendly hello and welcome to today's webinar, Preventing Sexual Harassment. My name is Deb Beto, and I will be your presenter today. My experience spans over 30 years, and 10 years ago, I founded my company called Your Ops Manager that manages the business operations of small businesses, including all of the elements of human resources. As an advisor to companies of less than 50 employees, we have been advising employers about discrimination, retaliation, and sexual harassment prevention since 2010. But enough about me, let's find out who you are. I have a few polling questions so that we can find out who is in the audience. And in order to do this, we are going to be using some of the interactive features of this webinar room. I realize that there may be participants who are sharing a computer with other participants. And in this case, when it comes to the polling questions, I recommend taking turns for who answers the polling question. But when it comes to using the free-form text box in the chat box, all of the participants can type answers in. To be compliant with California law, this training must include interactive questions and answers. In order to become familiar with the interactive features of this software, I will be asking a few questions right now to help you get used to polling responses and free-form text. For those of you watching on the video, you will be using questions number 1, 2, and 3 on your worksheet. So let's do the first one as a chat box free form text answer. Some of you may be sharing a computer, and if this case, you can use your free form text box to let me know who is in the room with you. So this will allow us to confirm all of the attendees today. And I would like to encourage those of you who are sharing a computer to take turns in answering today's questions. So let's do the first one as a question. The first one is going to be a polling question. So how many employees are there in your company? There's either 0 to 4, 5 to 19, 20 to 49, 50 to 249, or 250 to 499, or very unlikely 500 plus. And I say very unlikely because I really don't market to that business segment. So, all right. Now let's do one using the free-form text box. These are located in the lower right-hand corner of your screen, and you will use them to not only answer free-form text questions such as this next one, but also if you want to communicate with me during the presentation. You can hear me, but I can't hear you. So if you have a question or comment during the presentation, you will use this feature. And by the way, questions and comments are very much encouraged throughout the presentation. So free-form text box. What industry are you in? So use your chat box to let me know the answer to that question. Excellent. And we will do one more polling question just to find out who we have in the audience. For those of you on the video, this is your question number 3. What position do you have in the company? You're either an owner, supervisor, or a non-supervisory employee. Excellent. So if you are a business owner or a supervisory employee, you will be required to be participating for the full 2-hour presentation today. If you are a non-supervisory employee, you're only required to attend the first hour, and we will let you know when the non-supervisory employees can be excused. One of the mandates to fulfill your training requirements is to treat this as an interactive experience. Use the questions box or chat box to ask questions along the way. And if we don't get to your question during the presentation, we will follow up with participants by email after the presentation. There will also be mini quizzes and other interactive opportunities during the presentation. And while you will not be graded on your responses will be documented and provided to your employer as proof of attendance. So please be sure to participate in the interactive portions of this presentation. Okay, let's get started with our first mini quiz just to get some practice and to get a baseline of your knowledge on the materials. We will be using the polling feature for these questions. So at home, this is your question number 4. Okay, so these are all true, false. So true or false, individuals can be personally liable for sexual harassment. This one is true. It's not just the employer who is liable, but it's also the individual that is the harasser that is liable. Okay, number 2, volunteers and unpaid interns are not protected against sexual harassment in California. Is this true or false? This one is false. They are protected in California, but only under state law, not federal law. And I do realize that there may be participants on this session that are not employees in California. And I wanted to explain why you're required to take this workshop. California employers, in other words, any employer that is registered in the state of California, has to provide this training to all of their employees, regardless of their employee's location. So while we will be reviewing California law in this session, even if you are in another state, not all of the California laws might apply to that state. However, that doesn't mean that the information in this presentation isn't relevant. This is general information that is intended to prevent harassment in all organizations, regardless of the location. All right, our question number 3. Sexual harassment only occurs if a female is harassed by a male boss. Is that true or false? That one is false. It's been settled law for some time that same-sex sexual harassment is actionable under the Fair Employment and Housing Act. We'll refer to this throughout the presentation as the FEHA. Also, it doesn't have to be an employee. These laws also extend to customers and vendors. All right, number 4. Sexual desire is a key element to any claim for sexual harassment. Is that true or false? That one is false. Recent legislation clarified that existing law by expressly stating that sexually harassing conduct does not need to be motivated by sexual desire. The legislation was California Senate Bill 292, and it was passed to refute a previous decision in Kelly versus Conoco Companies, which was decided in 2011. So this recent legislation is within the last 10 years that says that sexually harassing conduct does not need to be motivated by sexual desire. So fairly recent legislation. Number 5, an employee can file a claim for sexual harassment even if the supervisor took no adverse employment action like termination, failure to hire, demotion, or anything like that against the employee. Is that true or false? That one is true. Number 6 on our little quiz here. An employee can only file a harassment claim if they experienced economic loss or other adverse employment action. Is that one true or false? So the crux of a harassment claim is that it's an assault on the complainant's personal sense of dignity and well-being. So this one is false. All right, number 7, in California, if the employee does not take advantage of the established internal complaint process, the employer has a complete defense to a sexual harassment lawsuit. Is that true or false? So that one is false. And we have one more. It's a good defense, but it's not a complete defense. And we'll talk about that in a little bit coming up. Number 8, California mirrors federal laws regarding harassment in the workplace. Is that true or false? So that one is false. We've already seen that in California, volunteers and unpaid interns are not protected against sexual harassment. Or I'm sorry, in California, they are protected against sexual harassment, but under federal law, volunteers and unpaid interns are not protected. So there are some differences, and we'll be going over those differences soon. And you're not expected to get all these questions right. So if you missed any, that's just fine. That's what we're here for, is to learn. Okay, so why do we have to do this training? Recent legislation has given the California Department of Fair Employment and Housing, otherwise known as the DFEH, broader authority in terms of investigation and enforcement. That's California. From a federal level, the Equal Employment Opportunity Commission, the EEOC, is the enforcement agency. And as a result of the authority of these two agencies, both employers and employees need awareness of what does and does not constitute harassment in the workplace. And while you won't get an unexpected visit from either one of these agencies, If you do find yourself in the middle of a complaint and you do not have any history or record of training, the penalties will be much worse because the employer did not take a proactive stance to avoid the lawsuit. Most importantly, though, there are definitely advantages of compliance. The enormous financial liability for an employer is only part of the concern. Sexual harassment contributes to decreased worker productivity, increased employee turnover, and lower workplace morale. Workers suffering trauma from harassment take more time off from work than the average employee, causing increased business costs from medical insurance. Sexual harassment may affect employee concentration and lead to increased accidents at work and frequent mistakes, contributing to a lower quality of work. So by creating harassment policies that are specific and providing and documenting harassment training, employers can decrease their chances of litigation. If an employer is taken to court, these documents will help to prove that the employees have been made aware of the company's stance towards harassment. This could potentially reduce the employer's share of the liability and penalties. Training can support and help strengthen an organization's culture by communicating its values, goals, and policies in creative and meaningful ways that motivate individuals to act ethically, while also protecting the organization and its reputation. All of this being said, if you approach harassment training with the sole purpose of avoiding litigation, then you're missing the boat as far as the effects that training could have on your organization. If you stop taking the avoiding litigation approach and instead take the promoting a healthy work environment approach, then you will find that employees and supervisors are focused on the achievement of organizational goals rather than the daily conflicts that occur in an unhealthy work environment. So how is a supervisor defined? A person qualifies as a supervisor under California law if they have the discretion and authority to do three things. Number one, to hire, transfer, promote, assign, reward, discipline, or discharge other employees, or effectively recommend any of these actions. Number two, to act on the grievances of other employees or to effectively recommend action on grievances. Or number three, to direct the claimant's daily work activities. So if any three of those scenarios exist, then it is a supervisory position for purposes of educating on preventing harassment training anyway. So why do non-supervisory employees have to take this training? Employers can be liable for harassment by non-supervisory employees if the employer knew or should have known about the harassing behavior and failed to take immediate and effective corrective action. So when employees don't understand what constitutes harassment, there is no chance to change the culture. When employees remain silent and shrug off offensive behavior, it normalizes sexual harassment and toxic or hostile work environments. So harassment training is designed to help everyone find their voice and give them tools to speak up. It's all about building a sense of community. It's about setting the tone for what's acceptable and what's not acceptable behavior. Okay, enough lecturing. Let's get into some interactive efforts here. So in this, we're going to match the year to the event. So this is a little bit of a history quiz. So in what year did Anita Hill testify against U.S. Supreme Court nominee Clarence Thomas? This was a landmark case in federal national history. It was either 1964, 1975, 1986, 1991, 1998, or 2018. And our answer is 1991. All right. In what year did the Me Too movement expose sexual harassment practices prevalent in the entertainment industry? It's either 1964, 1975, 1986, 1998, or 2018. This was more recent in history, which is 2018. And in what year did sexual discrimination become illegal? It was either 1964, 1975, 1986, or 1998. This one became illegal in 1964. It was the landmark case, not only for sexual harassment, but for all types of discrimination, which is the Civil Rights Act of 1964. All right, in what year is sexual harassment recognized by the Supreme Court as a form of sexual discrimination? It's either 1975, 1986, or 1998. So this one was 1986, and I'm going to tell you a little bit about this case. It's a case called Meritor Savings Bank versus Michelle Vinson. And this case ruled that speech in itself can create a hostile environment which violates the law. Michelle Vinson was a teller trainee at the age of 19 at Meritor Savings Bank in Washington, D.C. After a year on the job, she complained about her boss, Sidney Taylor, repeatedly sexually harassing her. She was fired in 1978 due to using too many sick days. This was 2 months after she initiated a lawsuit because she claimed that Taylor had coerced her to have sexual relations with him, which she did around 40 to 50 times over a 3-year period. Additionally, he repeatedly touched her in public, exposed himself to her, and forcibly raped her, which she said caused a hostile work environment. So that is the first time that that term was coined. The court decided that sexual harassment leading to non-economic injury is a form of sex discrimination under the Civil Rights Act of 1964. It also established that the sexual conduct between Taylor and Vinson could not be considered voluntary, even though she agreed to it. It could not be considered voluntary due to the supervisor-subordinate relationship in the workplace. So that was a landmark case. All right, our next question. In what year did the Supreme Court declare that same-sex harassment is unlawful at work? It was either 1975 or 1998. And this one was in 1998. So that leaves our last one. The first sexual harassment case came to court in 1975. And I'm going to tell you a little bit about that one. In 1975, Cornell University versus Carmenita Wood is the name of the case. And I'll just say that after this case was in court, Red Book, a famous magazine in the 70s, did a survey that came out in 1976. And this survey showed that 80% of the respondents had encountered sexual harassment on the job. So this case, publicized by Red Book, really exposed just how prevalent sexual harassment was in the workplace in the US in the 70s. So what happened in Cornell University versus Carmenita Wood? Well, Carmenita Wood was a 44-year-old mother of four and was an admin assistant to a man by the name of Boyce McDaniel. Boyce McDaniel was a renowned nuclear physicist on the Manhattan Project before becoming director of Cornell's Laboratory of Nuclear Science. And he made it a habit of looking her up and down lustily, brushing up against her body, and touching himself suggestively when she was nearby. And once after a Christmas party, he accosted her in an elevator and kissed her repeatedly on the mouth. Now, career-wise, Carmenita Wood had a lot of potential to move up the ladder, but a couple of years into working with Boyce, she started developing physical pain in her neck and her arm. She lodged a complaint and requested a transfer, but nothing ever happened, so she quit. And after not being able to find another job, she applied for unemployment and was turned down. After taking it to court, Cornell eventually gave in and gave her a job in a different department, but nothing ever happened to Boyce McDaniel. In fact, today, if you go to Cornell University, there is a garden on Cornell's campus that is honoring him. All right, so there are two types of sexual harassment: quid pro quo and hostile work environment, period. Those are the only two types of sexual harassment. The essence of a quid pro quo sexual harassment claim is that a supervisor relies on his or her authority to extort sexual favors from an employee. So quid pro quo is between a supervisor and an employee, and it is specifically related to extorting sexual favors. The threat may be expressed or implied. When it comes to hostile work environment, the courts have recognized three varieties of hostile work environment sexual harassment. One is a hostile work environment where the conduct is directed at the claimant. One is a hostile work environment where the conduct is directed at others, so it's observed by others. And the third one is a hostile work environment that is widespread sexual favoritism. The harassing conduct includes unwanted sexual advances that can either be verbal, visual, or physical. And to be able to bring a lawsuit, the unwanted behavior must be severe or pervasive. And it must alter the conditions of employment to the extent that it creates a hostile or abusive work environment. Some things to consider are the nature of the conduct, the frequency of the conduct, the period of time over which it occurred, whether the conduct was physically threatening or humiliating, the extent to which the conduct unreasonably interfered with an employee's work performance, and you can also have a hostile work environment that is not sexual in nature and would be considered harassment on its own without having to be sexual harassment. This becomes especially unlawful when it's directed at a protected class. And we will have some examples of the protected classes later on in this presentation. So let's do a little quid pro quo quiz. These are going to be true or false. So number one, the promise of reward or threat of punishment in exchange for sexual favors must be explicit in order to constitute quid pro quo sexual harassment. Is that true or false? That one is false. It can be explicit or implied. Okay, next question. An employee who gives in to the demand for sex in order to avoid negative consequences forfeits his or her claim for quid pro quo sexual harassment. Is that true or false? That one also is false. We just saw in the case of Michelle Vincent versus Meritor Savings Bank that because of the supervisor-subordinate relationship, it could not be considered consensual. And number three, if the alleged harasser denies the charge, A claim for sexual harassment cannot be successful without a neutral witness or documentary evidence supporting the complainant's accusations. Is that true or false? That one is also false. Of course, it's much easier to prove the claim if there are witnesses, but that doesn't mean it can't be proven, especially when it comes to how severe or pervasive it is and whether it's explicit or implied. So there's all these terminologies that you're hearing that would be taken into consideration in a case even without a witness. Okay, let's do a little scenario. Blanche is new on the job and is in training on product knowledge. She's having some challenges grasping the concepts behind which components of the products are interchangeable and which are not. She asks her supervisor, Daniel, for some help, and he suggests that they go out to dinner where he can take his time to teach her what she needs to know. Blanche is uncomfortable with this suggestion, but agrees anyway. During dinner, Daniel takes Blanche by the hand and tells her not to worry about her product knowledge, as she will eventually learn it, and if she hooks up with him, he will cover for her at work. So is this quid pro quo or not quid pro quo? Some things to consider are, this may not be quid pro quo because Blanche agreed to go to dinner with Daniel, and so she led him on. She led him to believe that she was interested in a social relationship outside of work. Or maybe this is quid pro quo because Daniel's request to hook up in exchange for covering for her at work is a request for sexual favors in return for benefits at work. So is this or is this not quid pro quo? So this one definitely is quid pro quo. Quid pro quo, we have a supervisor-employee relationship, and we have an explicit, if you hook up with me, I will cover for you at work. So there is a sexual nature and something in exchange for sex. So it definitely is quid pro quo sexual harassment. All right, our next scenario. Kim and Nicholas are co-workers in the same department. Their boss, Anna, has an unpredictable nature, and Kim and Nicholas frequently have lunch out together to talk about Anna's mood of the day. After several months of these lunches, Nicholas admits to Kim that he is interested in a more romantic relationship with her. Kim declines Nicholas' request, and as a result, Nicholas stops having lunch with Kim, although they still work well together on the job. So is this quid pro quo or not quid pro quo? Some things to consider are that maybe this is not quid pro quo because neither Nicholas nor Kim are in a position to influence employment decisions affecting one or the other. Or maybe it is quid pro quo because Nicholas stopped having lunch with Kim, which is a negative consequence of Kim's refusal of his advance. So is this quid pro quo or is this not quid pro quo? Okay, this one is not quid pro quo. Human interactions are complex, and sometimes the lines are unclear between what is okay and what isn't. And in fact, what is okay for one person may not be okay for another. So it's important to distinguish between human interactions that may be awkward or even illegal for other reasons and what is quid pro quo sexual harassment. Quid pro quo sexual harassment is not a consensual relationship between a superior and subordinate that doesn't have any effect or anticipated effect on employment decisions. It's not a consensual relationship between employees who are not in a position to influence employment decisions affecting one or the other partner, like Kim and Nicholas. And it's not any sexual harassment that does not involve a this for that exchange where sexual activity is linked or even perceived to be linked to employment decisions. And also quid pro quo is not any this for that exchange that is not sexual in nature, but it might affect employment decisions. For example, the exchange of money or favors that are not sexual in nature for employment benefits or to avoid negative consequences. So sexual harassment quid pro quo is very narrowly defined and in the law. Okay, couple of true-false questions here regarding hostile work environment. So number one, to prove hostile work environment sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. Is this true or false? This one is true. They do not need to show that they suffered an adverse employment action. Number two, to prove hostile work environment sexual harassment, the complaining party must show that they were subjected to unwanted sexual attention that was both severe and pervasive. Is that true or false? This one's a tricky one. A little bit of word tricks here. This one is false. It is severe or pervasive, not severe and pervasive. You can have one severe episode that can justify a lawsuit, or you can have frequent, less severe conduct that justifies the lawsuit. So it's severe or pervasive. Tricky one there. Verbal harassment can be the result of personality conflicts in the workplace that have escalated beyond the casual eye roll or something more serious. Unlike discriminatory types of harassment, such as sexual harassment, verbal abuse is often not illegal. And this just relates to a verbal hostile work environment. Is not related to sexual harassment specifically, but it's more related to harassment in the workplace. And verbal harassment can be someone who's consistently mean or unpleasant, as well as everything that is listed on this worksheet here. And for this reason, a lot of verbal harassment can be particularly damaging since it goes unnoticed and unresolved. Examples of verbal harassment are foul or obscene language, derogatory comments, explicit discussions about sexual activities, and comments about other people's physical attributes. Obvious verbal harassment behaviors include things like threatening, yelling, insulting or cursing at a victim in public or in private. And if this is aimed at someone in a protected class, which we will review shortly, it is unlawful. Again, visual hostile work environment, again, not necessarily sexual harassment, but workplace harassment. Visual hostile work environment is an insult to the employee's sight. And visual sexual harassment can include obscene gestures and looks or sexually explicit images in the forms of office posters, email attachments, photographs, screensavers, wallpaper on a computer, nude calendars, and other graphic images that might offend someone. And physical harassment, including workplace violence, refers to a type of workplace harassment that includes physical touching, attacks, or threats, and in extreme cases, physical harassment may be classified as assault. Physical gestures, such as playful shoving, can blur the line between appropriate or not. And since it's the person on the receiving end who decides whether the behavior makes them uncomfortable, you need to know who you're working with. In order to more clearly define that line, physical harassment should be taken very seriously in the workplace and explained thoroughly in codes of conduct and policies. Common behaviors include direct threats of intent to inflict harm, physical attacks like hitting, shoving, and kicking, threatening behavior like shaking your fists angrily at someone, or destroying someone's property in order to intimidate them. So we'll go through some exercises and have you identify whether they are verbal, physical, visual, or none. And this is related to workplace harassment, and could be also sexual harassment. So let's start with the first one. Jackson starts a new job and notices that he is the only non-white person in the company. He is excluded from friendly discussions, and when he tries to join, coworkers speak slower to him as if he doesn't understand English and asks him what his people think about things. Is that verbal, visual, physical, or none? So this one is verbal. It's a conversation taking place between people, so it's verbal. Maisie alleges that while working as a lifeguard, male supervisors groped her and other female lifeguards and entered their locker room without knocking. Is that verbal, visual, physical, or none? And I just want to go back to the scenario before with the Jackson scenario. That's not sexual harassment, but it is workplace harassment. So just want to make that clear that we are doing a presentation not only on sexual harassment, but harassment in the workplace in general. So on this polling question, we've got physical. So they groped her and they entered their locker room without knocking. So that's definitely physical harassment. Regina's coworker, Aaron, often poured out his relationship woes to her. During these conversations, he would touch her elbow. Sometimes he called her at home to complain about his failed romantic relationships. Is this verbal, visual, physical, or none? This one is a little bit tricky. The fact that he sometimes touched her elbow could be construed as physical, but it really is none, because a reasonable person having their elbow touched would not necessarily find that to be harassment or even sexual harassment. So unless Regina specifically tells him, don't touch me like that anymore, it's not really considered harassment. So this one is none, which means our last one is every time Chris walks past Pat's desk, she makes gestures that suggest oral sex. This is definitely a visual harassment, and it was the only one that we hadn't seen on the list yet. Also going back to the Regina scenario, again, some situations might be really uncomfortable, but they don't necessarily meet the high standard that the courts would construe to be a hostile work environment. A hostile work environment must be severe or pervasive. And a touching of the elbow is not severe. And even though he does it, as they go out to lunch, it's not pervasive. Okay. California recently added abusive conduct as part of the definition of workplace harassment. Abusive conduct means conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act does not constitute abusive conduct unless it's especially severe and egregious. So again, we come up against that severe and pervasive. So here, if a single act is severe and egregious, it may constitute abusive conduct, but what we're looking for are patterns of hostile work environments that go unreported. Normally, the severe and pervasive ones are being reported. So this is an example of, so Christina alleged that she was sexually harassed by her supervisor, Robert, over the course of a year. After a year, Christina told a coworker, Max, about her supervisor's behavior. You know, it seems like I skipped a slide here. I'm going to go back. Yes, I did skip a slide. Here we go. So when there is an allegation of harassment, these are the typical types of defenses that you would see an employer make. So the denial defense. It never happened. There were no witnesses. Look at how she dresses. I'm just a hugger. Did you ever hear of a woman scorned? If I don't say she's hot, she's not going to get the job done. So those are the denial defenses. Under welcomeness, that means that the conduct complained of was welcomed by the plaintiff. The definition of welcomeness endorsed by the EEOC is that the conduct must be unwelcome in the sense that the employee did not solicit or incite it, and in the sense that the employee regarded the conduct as undesirable or offensive. It's not enough that the plaintiff believed the conduct to be distasteful. It must be demonstrated by a preponderance of the evidence that the plaintiff, by his or her own conduct, indicated that the complained of behavior was in fact unwelcome. So it's up to the complaining party to make sure that the person that is doing the harassment understands that the harassment is unwelcome. Under a reasonable person defense, the conduct would not be considered offensive to a reasonable person. And when applying the reasonable person standard, it's important to apply context to the situation. The EEOC uses this example specifically. Tricia alleges that her coworker made repeated unwelcome sexual advances towards her. An investigation discloses that the alleged advances consisted of invitations to join a group of employees who regularly socialized at dinner after work. The co-workers' invitations, viewed in that context and from the perspective of a reasonable person, would not have created a hostile environment and therefore did not constitute sexual harassment. A reasonable person standard also should be applied to make a determination of whether the challenged conduct is of a sexual nature. Therefore, in Tricia's example, a reasonable person would not consider the coworker's invitations sexual in nature, and on that basis as well, no violation would be found. Another type of defense is called the failure to mitigate damages. This means that the amount of harm to the victim could have been less if the employee had taken action. If the victim could have avoided harm, then no liability should be found against the employer who had taken reasonable care to prevent that harm. And if damages could reasonably have been mitigated, then no reward should be given to the plaintiff for what their own efforts could have avoided. So this is meant to prevent frivolous lawsuits or damaging lawsuits, that employees who could have prevented it should have taken measures to prevent it. Which is also very similar to the avoidable consequences doctrine. The avoidable consequences doctrine is a legal principle that places the responsibility of minimizing damages upon the person who has been injured. So the victim could have avoided part or most of the harm if they had taken advantage of the employer's procedures for addressing sexual harassment. And this goes back to the importance of the employer to actually have policies and procedures that are clearly communicated to their employees. So that brings me to an example of the avoidable consequences doctrine. Christina alleged that she was sexually harassed by her supervisor, Robert, over the course of a year. After a year, Christina told a coworker, Max, about her supervisor's behavior, but she did not formally report it to management until a year after telling Max. So by this time, 2 years have gone by. When Christina finally did complain, her employer investigated Christina's allegations and determined that Robert had, in fact, violated the employer's sexual harassment policy. Robert was disciplined and eventually retired as a result of the findings. Christina subsequently sued Robert and her employer for, among other things, sexual harassment in violation of California's anti-discrimination law, the Fair Employment and Housing Act. Her employer asserted various affirmative defenses, including the argument that Christina's failure to promptly invoke the employer's anti-harassment policies and procedures provided it with a complete defense to her claim. So this defense has 3 elements. Number 1, the employer did take reasonable steps to prevent harassment because they had a policy in place, and that policy identified how Christina should have reported the sexual harassment. Number 2, the employee unreasonably failed to use the preventive and corrective measures that the employer provided because she didn't report it to her employer for 2 years. And number 3, reasonable use of the employer's procedures would have prevented at least some of the harm the employee suffered. So after she reported it, immediate action was taken. So if she had reported it on the first incident, she would have avoided the other 2 years of the harassment. So that's the avoidable consequences doctrine and an example of it. So when interpreting the laws, you are wise to recognize that there is a difference between federal law and California law. Federal law is more restrictive and California law is more all-encompassing, almost encouraging employees to bring a lawsuit. Federal law assumes the employer is innocent until proven guilty, and California law assumes the employer is guilty until proven innocent. There's also some distinctions between the classes of discrimination between federal law and California law. I'm going to share with you the 8 classes of discrimination recognized by federal law, and then I want you to use your chat box or write down on your piece of paper to tell me some of the additional 10 classes that are recognized in California. So first of all, the federal classes: race, color, national origin, citizenship, gender, religious creed, physical disability, and age over the age of 40. So these are the federally protected classes that all started with the Civil Rights Act of 1964, especially as it related to race and color and national origin. So these are the 8 protected classes in federal law. I want you to use your chat box to tell me the other 11 classes that are in California. Or I guess it's 10 in California. So go ahead and use your chat box, and I will wait here for a second while you're doing that. So there's 10 additional ones recognized in California. And there's some tricky ones here. So we'll go through them. As a subset of national origin, we have ancestry. As a subset of gender, We have gender expression, gender identity, sexual orientation, and gender characteristics. As a subset of physical disability, we also have mental disability and medical condition. We also, in California, have military and veteran status, familial status, which could be considered marital status, and the newest one in 2020 in the state of California is natural hairstyles. So I'm going to just highlight the sexual orientation, gender identity, gender expression, and transgender because these are fairly new. And despite the worldwide shift towards greater acceptance of non-traditional gender roles, individuals perceived to have non-conforming gender expression continue to be victimized and subjected to discrimination. Non-conforming gender expression or conveying feelings of masculinity or femininity through one's appearance and behavior in a way that society has assigned to one's biological sex has been linked to a lot of negative outcomes, including verbal and physical harassment, parental and peer rejection, bullying, substance abuse, and suicide. In our workplaces, we have a responsibility to monitor the effects of discrimination and reduce its prevalence. So let's review the DFEH definitions of the non-traditional gender roles that are considered illegal to discriminate against in California. So first we have sexual orientation, which the DFEH defines as heterosexuality, homosexuality, and bisexuality. Second, we have it's illegal to discriminate based on gender identity, which the DFEH defines as a person's internal understanding of their gender or the perception of a person's gender identity, which may include male, female, a combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Again, these are definitions by the DFEH. It's also illegal to discriminate based on gender expression. And gender expression, as defined by the DFEH, is a person's gender-related appearance or behavior or the perception of such appearance or behavior, whether or not stereotypically associated with the person's sex assigned at birth. And lastly, it's illegal to discriminate based on transgender, which the DFEH defines as a person whose gender identity differs from the person's sex assigned at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex assigned at birth. A transgender person may or may not identify as transsexual. So there's been a lot of confusions over those 4 classes of discrimination. So I think it's important to understand what the definitions are so that we can avoid the discrimination. So I want you to use your questions box or chat box to ask any questions about any of the material that you didn't understand or that might require some clarification. And if you have any questions that you're uncomfortable asking in this group setting, then please email your questions to training@yourcompliancemanager.com after the session today, and we will respond to your question by email within 24 hours. Also, if you are a non-supervisory employee, I want you to email your answer key from today's session to training@yourcompliancemanager.com with the subject being COC. If you use the subject COC when sending your answer key to us, then we will know that you are looking for your certificate of completion of today's webinars, and we will email that certificate of completion to you. Again, subject COC to training@yourcompliancemanager.com. If you participated on the live webinar, you don't need to do that. We will get your certificate out to you within 1 working day. So non-supervisory employees can log off here. And before you do, I'll mention a few things to all of the participants. A copy of this PowerPoint deck will be made available to the person who registered the participants for your company. And a certificate of completion will be emailed to both you and the person in your company that paid for your registration as proof of attendance today. So thank you to all of our participants who are not business owners or supervisors. You can now log off and have a great day. And for those of you who are business owners or supervisors, please stay on for the second hour. Thank you. For our second required hour of training, we will be reviewing best practices for employers and supervisors. So in this section, we will be asking you to use your chat box to give us the answers to your questions. We've used up all of the polling questions available on this site. So from now on, we're going to ask you to use your chat box or questions box to communicate your questions and answers to us. So our first question in our mini quiz: the DFEH can seek injunctive relief to compel employers to take all reasonable steps to prevent unlawful discrimination without proving an underlying violation of the FEHA. Is this true or false? Kind of gave the answer there. Sorry about that. So you should all get this right. And this one is true. It is unlawful for employers to fail to take all reasonable steps to prevent discrimination, harassment, and retaliation. Number 2, the employer's duty to take immediate effective action in response to a claim of sexual harassment only applies where there is a credible report or threat of unwanted physical contact. Is this true or false? And this one is false. Again, an employer needs to take all reasonable steps to prevent discrimination, harassment, and retaliation. And it's dependent upon numerous factors, sometimes that are unique to the particular employer, including things like workforce size, the budget, the nature of the business, and the facts of the case. So we're going to go over the California codes. I don't want you to memorize these codes, but if you ever question whether something is unlawful or not, keep this list handy so that you can compare your situation to the codes. So the first one is California Government Code 12940, subchapter J, subchapter 1, which makes it unlawful to harass an employee, an applicant, an unpaid intern or volunteer, or a person providing services under a contract. California Code 12940 J4A defines that an employer means not only the traditional types of businesses, but also an interpretation that is meant to include sole proprietors that don't even have employees. California Government Code 12940 J4C defines harassment, including sexual harassment, gender harassment, and harassment based on pregnancy, childbirth, or related medical conditions. This is the code that says sexually harassing conduct does not need to be motivated by sexual desire. California Government Code 12940K makes it unlawful to fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. And lastly, California Code of Regulations 2 CCR 11203 defines harassment and discrimination prevention and correction. So again, I don't want you to memorize these codes. I just want you to keep this list handy so that if you ever do find yourself in a lawsuit, you can compare your situation to the California code. So here's a little quiz. I want you to use your chat box or your piece of paper if you're watching this on YouTube. Otherwise, go ahead and use your chat box. And which of the following are not protected under California Government Code 12940J1? Is it an outsourced bookkeeper, someone that walks in unannounced looking for a job, paid interns, an IRS auditor conducting an audit, or are all of the above protected under the code? So this was a little tricky. The outsourced bookkeeper is a person providing services under a contract, which is protected by this code. Job applicants are always protected by the code, whether they're supposed to be there or not. And we mentioned that unpaid interns were protected, but actually anyone that is paid is an actual employee, even if they're working as an intern. So the IRS auditor is the only one that doesn't fit the definition of employee, applicant, unpaid intern or volunteer, or a person providing services under a contract. You're not under contract with the IRS auditor. Now, I'm not encouraging you to harass your IRS auditors because you're not going to pass your IRS audit, but at least under this California code, you've not broken the harassment rules. All right, another quiz. If you are a sole proprietor with no employees, you are not considered an employer under California Government Code 12940J4A. Is that true or false? Now, this one doesn't seem fair. It's false. It's not a fair question because if you are a sole proprietor with no employees, you don't even have to comply with this new regulation that requires you to take this training. So you're probably not even on this webinar. However, that doesn't mean that sole proprietors don't have to comply with all of the California codes. And under this code, you are defined as an employer. Okay, which of the following is not a type of harassment under California Government Code 12940J4C? Is it gender harassment, performance-based harassment, medical condition harassment, sexual harassment, or all of the above are types of harassment under the code? So this code has to do specifically with sexual harassment. And even though performance-based harassment can create a hostile work environment, this code defines sexually harassing conduct, even if it's not motivated by sexual desire. So performance-based harassment is the one that doesn't fit in this category here. By requiring that all employees participate in training on a regular basis, organizations can send a clear message from the top that when it comes to preventing harassment and other abusive behavior and creating a respectful workplace, we are all in this together. When all employees are trained and are on board with understanding the policy, the most important aspect of harassment prevention begins, which is consistency. The leadership must create a culture where employees feel comfortable in reporting what they've either seen, heard, or read. You need to keep conversations private and help the employee understand that there is zero tolerance for workplace harassment. Policies and training must be reinforced by leadership. the managers and supervisors must understand that their obeying of the law and internal policies is required. Top management should model the desired behavior and provide appropriate support to managers and supervisors on the front lines. So make sure your company has a written policy that, number one, defines sexual harassment and discrimination, number two, prohibits such conduct, and number three, provides a complaint and investigation procedure. The policy should identify appropriate personnel who employees can report their complaints to, and state that the company will promptly investigate any complaints without retaliation. Distribute this policy to each employee at the time of hiring and also to all employees at least once a year. Post the policy in a conspicuous place where employees can easily access it. And make sure each employee signs a receipt of the policy, preferably each time he or she receives a copy. And keep all the signed receipts in the employee's personnel file. When it comes to training your employees and supervisors, what you're experiencing today is a basic training that keeps you in compliance with the laws about training. But if your organization has experienced some difficulties, you may want to consider something less basic and more specialized for your organization. And here are just 3 examples that we will look at a little deeper of the types of trainings that are available. Implicit bias is also known as unconscious bias. Unconscious biases are learned stereotypes that are automatic, unintentional, deeply ingrained, universal, and able to influence behavior. Unconscious bias training programs are designed to expose people to their unconscious biases, provide tools to adjust automatic patterns of thinking, and ultimately eliminate discriminatory behaviors. It's well known that people don't always speak their minds, but maybe people don't always know their minds. We don't have unconscious biases because we're bad people. We have them because we are people. What this means is that we all have some sort of bias or preference that we may not even be aware of. So for example, we may say that we prefer someone more mature for the job in comparison to a millennial, for example. But in actuality, if we perceive ourselves as younger than our actual age, then we may actually prefer younger people instead of older people. It's an unconscious bias. Becoming aware of our actual preferences to things like age, race, religion, and other diversities can help us to eliminate those biases to a greater extent than if we are not aware. Harvard University has done a lot of research into implicit bias testing, and as a result of their publishing their testing results, there are a lot of companies who have come into existence that can go into an organization and do implicit bias training if you feel like this has a big influence on your hiring, your performance, your equal pay, and your promotions practices. So here's some types of implicit bias. Affinity bias. Affinity bias is a tendency to be more receptive to people who resemble our lives in some way. So for example, imagine a job recruiter saying, well, I hired her because she reminded me of my sister. That's an example of affinity bias. Confirmation bias is looking for information that supports our beliefs and ignoring details to the contrary. Now, imagine someone saying something like, well, he's from Appalachia, so of course he isn't very well educated. This is an example of confirmation bias at work. The halo effect happens when we like something about someone, and therefore we assume that everything about them must be great. For example, imagine a teacher saying something like, My student is so well behaved, so he must also be smart. That's the halo effect. Perception bias is stereotyping people based on a group that they belong to. For example, imagine someone saying something like, many crimes are committed by this particular ethnic group, so a person of that same ethnicity must be a criminal. That's perception biased. And bandwagon bias is very popular among teenagers. This is simply believing something because others believe it. You've probably seen this expressed with one of your teenagers saying something to the effect of, well, no one else enjoyed that movie, so neither did I. So that's bandwagon bias. You want to be accepted as part of the group. Another type of training that's available is interaction with certain groups. So don't take complaints from employees lightly, even if the offense described does not initially seem serious. Take all complaints as an opportunity to enter into group discussions about ways to improve the overall effectiveness of the company. For example, if Tamika complains that she is always having to take the overtime shift, then maybe it's a good idea to have a meeting with everyone that would be eligible to take the overtime shift and get feedback from everyone. The insight you could learn is valuable, but it will also be valuable to Tamika to know that she is being heard. And if in your discussion you uncover a situation where Tamika really is being treated differently than the other employees, then you could find yourself avoiding a potential EEOC or DFEH complaint. Bystander intervention training provides participants the opportunity to see themselves as potential active bystanders who can intervene when they witness abusive, isolating, or stigmatizing behavior. It teaches them how to be the hero in the group. The training teaches them to be more aware of why they may be hesitant to intervene and encourages them to consider taking action in the future. This type of training teaches employees how to evaluate and respond to problematic behaviors in the workplace, empowering them to interrupt difficult situations such as sexual harassment. So we're going to go through some examples, and I'm going to have you tell me what type of training would be good here. So Josh is the HR manager in charge of hiring at his organization. The last 3 people Josh has hired into executive positions have been people he has known through his synagogue. Because he is friends with these people, he often socializes with them at lunch and after work. Ian, who has worked with the company for a number of years, lodges a complaint that he is being deliberately excluded from social functions because he's not Jewish. Which type of training may be good for this organization? So again, the types of trainings that we went over are implicit bias training, interaction with certain groups, or bystander intervention. What do you think would be a good opportunity for this organization? So this one would be a great opportunity for implicit bias training. Josh may or may not be hiring people because he has an affinity towards Jewish people, but implicit bias training would accomplish 2 things. First of all, Josh could learn whether he does have a tendency towards affinity bias or not, and Ian will know that the company takes his complaints seriously, thereby allowing the company to avoid a complaint to the EEOC or DFEH. And if you really wanted to do this the right way, you would include everyone in the company in the training as a means of getting to know each other better, and also as a means of understanding your own implicit bias tendencies. Here's another example. Kelly has an office next door to the lunchroom, and she often overhears her coworkers' conversations. She often hears her boss, Margarita, teasing a particular coworker, Adam, about sexual things she would like to do with him if she was just 10 years younger. Adam walks away and rolls his eyes at Kelly as he passes her office. Kelly returns the eye roll and goes back to work. This behavior persists for a number of months until Adam quits working for the company and files a sexual harassment claim. So which type of training may be good for this organization? Implicit bias, bystander intervention, or interaction with certain groups? This is a great opportunity for bystander intervention training. Kelly was obviously aware of the improper behavior and that it bothered Adam, but she did nothing about it. Was this possibly caused by the fact that it was her boss and she was fearful for her job? Well, bystander intervention training would teach her techniques to intervene that could save both her job and Adam's job. When it comes to investigations, California has specific requirements for employers investigating complaints of harassment. Prompt and thorough are the two words to remember. Failure to follow California requirements can expose an employer to just as much liability as the harassment itself. California requires a third-party licensed investigator to complete the investigation. The investigator does not have to be licensed if they are an attorney or if it's done by an employee of the company. So you can't hire my firm, for example, or another HR professional unless they are specifically licensed for this type of work, which I am not. The most important thing to remember during an investigation is to do nothing to the complaining party that could be viewed as a punishment. This includes transfers, reductions in hours, or anything else that penalizes or isolates them. Failing to follow your own policies, delays to respond to complaints, and failing to interview witnesses identified by the accused party will allow the opposing attorneys to raise doubts about your investigation. Sometimes the investigation can be handled within one meeting with the employee if the basis of their complaint does not raise any unlawful conduct or a violation of company policies. In other words, they're just complaining. But if the complaint does raise any unlawful conduct, you need to hire an investigator that is licensed to conduct harassment investigations and is also impartial. If you use an internal employee as the investigator, including your human resources personnel, an actual or potential conflict of interest or bias can be raised. Also, designating an employee or supervisor as the investigator will not suffice if that person lacks knowledge of the laws. So most often, hiring an employment attorney with the advantage of attorney-client privileges to conduct the investigation is the best path. The investigation could cost more than designating someone in-house, but the money saved from the litigation and the verdict costs of a poorly run investigation is well worth it. It also sends another strong message to the complaining party that you take their complaint seriously. And it could also deter someone else from making a false claim in the future because they know their falsehoods will be uncovered. Oftentimes, the he said, she said scenarios come down to who is more credible in a case that could come down to proving beyond a reasonable doubt. So impartial investigators will be able to provide valuable insight into the scenarios that a judge or a jury would encounter. And one good rule to follow is to document every step of the investigation. The most critical piece of documentation will be written statements from key witnesses. Having it in writing will minimize the opportunity that people will have to change their stories. Keep the complaining party informed of the investigation status on a frequent basis. If you need to let them know that you're taking their complaint seriously. If it's concluded that there was harassment, take actions immediately to stop it and follow up with the complaining party periodically to make sure that there have been no further issues. So I'm going to have you use your chat box and we're going to do a little investigations do and don't quiz. This will go pretty quickly. So if you're watching this video, please make sure to write these answers down on your piece of paper and we'll go through this. So do or don't Be prompt and thorough. Do or don't, that one is a do, sorry. Do or don't use a licensed investigator. Do use a licensed investigator. Do or don't hire an outsourced HR professional to do your investigation. Don't hire an outsourced HR professional unless they are licensed for this type of work. Do or don't punish the complaining party. Don't punish the complaining party. Even something as simple as moving their cubicle away from the person that supposedly harassed them can be construed as punishment. So don't do anything that can be construed as punishment to the complaining party, because it can be seen as retaliation for the complaint. Do or don't follow your policies. Of course, you do need to follow your own policies. That's one of the most important things about leadership is leading by example. Do or don't delay responding to a complaint. Don't delay responding to a complaint. Do or don't interview witnesses identified by the accused. Do interview witnesses identified by the accused as soon as you can, and make sure that you get their written attestation of what they witnessed so that they don't have a chance to change their story later. Do or don't document every step of the investigation. Do document every step of the investigation. So hopefully you got all of those right. So an employee files a harassment claim. Now what? This is where the real fun starts. There may be situations where you need to separate the supervisor from the accuser until the investigation is done. And in many cases, an employer can accomplish this without suspending the accused employee. If you believe a paid suspension is necessary, consider consulting legal counsel first. Do not transfer the accuser or make any other accommodations that could be construed as retaliatory. If the accused party is a supervisor, do not use an employee for the investigation, especially if it is a senior manager where the employee acting as the investigator would have difficulty in being impartial. The best course of action to take if you are the supervisor and you know you did something wrong is to confess, apologize, promise to never do it again, and hope you won't get fired. But if you are wrongly accused, the best course of action to take is to cooperate with the investigation. Because you are innocent, instinctively, your first reaction may be to push back and stonewall the investigation. But in reality, you want the investigation because you want your side of the story on the record and you want to clear your name. So start by providing your list of witnesses who can back up your side of the story. Sometimes there's some gray area that you need to address. For example, you know you broke company policy by having a consensual relationship with someone, but after a bad breakup, the accusations of sexual harassment just are not true. You will serve yourself and the company best if you admit to what you did wrong and cooperate with the sexual harassment part of the investigation. You may still be fired for breaking the rules, but you already knew that when you started the consensual relationship, and it's far better to be fired for breaking the rules than the personal liability that comes with committing sexual harassment. Another thing you can do to help your case, even if you're wrongly accused or if someone took an innocent comment in the wrong way, is to apologize. Sometimes the accuser just wants to know that they're being taken seriously and that they're being heard. A sincere apology for not being sensitive to their interpretation of the events, maybe even without admitting any wrongdoing, can go a long way to avoid a lawsuit. Of course, you will also make a mental note that this person is more sensitive than other people that you may encounter in your life, and let that guide your future interactions with this specific person. Once the company has decided to hire an investigator, you may want to consider hiring your own attorney if the charges are serious enough. Make sure that it's an attorney that understands the employee side of employment law. It's not only your job on the line, but also your reputation and the fact that you could be held personally, financially liable for any financial judgments. You will need to pay for the attorney out of your own pocket, but the cost of the attorney will be far less than the cost of losing your job or losing a lawsuit. Also, if the investigation or trial finds you responsible, your attorney can assist in negotiating your punishment. They're good negotiators, especially in court cases. Employers have to track compliance with this new California Assembly Bill 1825 law by keeping training records indicating the date and time of the training provided, the trainee's name, as well as the name of the instructor. These records must be maintained for at least 2 years. Employers can provide trained supervisors with a certificate of attendance and place a copy of the certificate in their personnel file for the duration of their employment, plus 4 years post-employment. And keep in mind that supervisors who are hired into a position or are promoted to supervisor status have to complete a preventing harassment training within 6 months of assuming their position. So as part of this webinar today, you will be receiving certificates of completion for each attendee that includes today's date and my name as the instructor. So if you keep copies of these certificates for 2 years, you will be in compliance with the record keeping aspects of the law. But there's actually some conflicting record keeping aspects. So I would just keep the certificates for as long as you have the employee employed in your organization, plus 4 years post-employment. So why is this training law coming into effect for employers right now? I think you can thank Harvey Weinstein and the entertainment industry for that one. But in reality, I will provide you with some statistics that make this training important. The viral hashtag #MeToo and the increasing number of sexual assault allegations from many different industries make the prevalence of sexual harassment in the workplace obvious. The EEOC, which is the Equal Employment Opportunity Commission, is the federal government agency that oversees the regulations around workplace harassment. And they released a report with their findings of sexual harassment in the workplace. And here's what they found. So this is a report from 2016. In 2016, the EEOC published a report titled the Select Task Force on the Study of Harassment in the Workplace. And they found in 2016, 45% of the EEOC's harassment claims were sex-based. So in 2015, the EEOC received over 28,000 harassment claims. 45% were sex-based, which was the majority percentage compared to race, disability, age, national origin, and religion. And even though many harassment claims go unreported, those that are reported are overwhelmingly due to sexual harassment. The report also published that at least 25% of women experience sexual harassment in the workplace. That is 1 out of every 4 women that report sexual harassment. This is a disturbingly high number. 75% of harassment victims experienced retaliation when they reported it. So when reports come out about the high percentage of women experiencing sexual harassment, the most common response is, well, why didn't she say anything? Why didn't she report it? And the most common reason that the victims say is because they worry that not only will they not be believed, but they also will be fired. In fact, a study from 2003 found that 75% of employees who spoke out against workplace mistreatment faced some sort of retaliation. 75%. Others said that their complaints were minimized or not responded to at all. The report said that at least 87% of employees experiencing harassment do not file a complaint. Well, considering that 75% of employees who report harassment experience retaliation, it's not surprising that many choose not to take any type of formal action against a harasser. However, the types of complaints reported seem to follow how severe the harassment is. So sexually coercive behavior is reported more frequently, while unwanted physical touching probably occurs more often, but is reported less frequently. The report also found that sexual harassment costs companies millions. In 2015, the EEOC reports that victims of harassment were paid $164.5 million by their employers. That is just 1 year alone. So also in the report, the EEOC has identified a list of risk factors in the workplace where the characteristic described might become workplaces more prone to experience harassment. Now, most workplaces will contain at least some of the risk factors, but that doesn't necessarily mean that harassment is occurring in that workplace. Rather, it suggests that there may be fertile ground for harassment to occur and that an employer may wish to pay extra attention in these situations, or at the very least be cognizant that certain risk factors may exist. So we're going to review the EEOC risk factors. First one is a homogeneous workforce. Not surprisingly, harassment is more likely to occur where there is a lack of diversity in the workplace. For example, sexual harassment of women is more likely to occur in workplaces that have primarily male employees. Workplaces where some employees do not conform to workplace norms. Harassment is more likely to occur where a minority of workers does not conform to workplace norms based on societal stereotypes. For example, a feminine acting man in a predominantly male work environment that includes crude language and sexual banter. Now, it might seem ironic that workplaces that are extremely diverse also pose a risk factor for harassment. And this has been found to be the case, especially when there's been a recent influx of individuals with different cultures or nationalities into a workplace, or where a workplace contains significant blocks of workers from different cultures. Different cultural backgrounds may cause employees to be less aware of laws and workplace norms in the United States. Events and coarse social discourse that happen outside the workplace may make harassment inside a workplace more likely or perceived as more acceptable. So for example, after the 9/11 attacks, there was a noted increase in workplace harassment based on religion and national origin. Workers in their first or second jobs may be less aware of laws and how workplaces are supposed to happen, and they may lack the maturity to understand or care about consequences. Also, young workers who are the targets of harassment may lack the self-confidence to resist unwelcome overtures or challenge the conduct that makes them uncomfortable. Workplaces with high-value employees. Senior management may be reluctant to challenge the behavior of their high-value employees, And the high-value employees may believe that the general rules of the workplace do not apply to them. And on the flip side, low-status workers may be susceptible to harassment, and high-status workers may feel emboldened to exploit them in workplaces where there is significant power disparities. Low-status workers may be less likely to understand internal complaint channels and may also be concerned about the ramifications of reporting harassment. And this is especially true in companies that hire undocumented workers, because the undocumented workers feel vulnerable that they will get sent back to their home countries because they don't have the proper documentation to be here, so they allow themselves to be harassed more readily. In workplaces that rely on customer service or client satisfaction, if an employee compensation is directly tied to customer satisfaction, then employees may feel compelled to tolerate inappropriate and harassing behavior from the customer. And management may be unwilling to confront a good customer on the worker's behalf for fear of losing the customer. In jobs where workers are not actively engaged, harassing or bullying behavior may become a way to vent frustration or avoid boredom. Isolated workplaces. If harassers have easy access to isolated individuals and there are generally no witnesses to the harassment, then this becomes a very vulnerable situation. Workplaces that tolerate or encourage alcohol consumption. Alcohol reduces social inhibition and impairs judgment. So it's not surprising that workplace cultures that tolerate alcohol consumption provide a greater opportunity for harassment. Decentralized workplaces. So think about a store at an outlet mall that might be part of a national chain, and the management is located in New York. That's the branch location here in our outlet mall is a decentralized workplace, meaning that there is limited communication with organizational levels, and it may foster a climate in which harassment may go unchecked. Now, again, almost every workplace has components of these risk factors, and it doesn't mean that it will necessarily result in harassment in the workplace. The objective of identifying and describing these risk factors is to provide a roadmap for situational awareness. Now, I would like to challenge you to take this training today one step further. Take a minute right now to review the risk factors on this list and honestly identify which of the risk factors could be part of your organization. If you then send me a request to training@yourcompliancemanager.com, I will send you the EEOC recommended strategies to reduce the harassment according to the risk factor that you identify. Now, I won't be bombarding you with emails or sales calls, so if you want this information, you're going to have to request it. So again, training@yourcompliancemanager.com. So now we can see that at Miramax, they had a workplace with a high value employee and a significant power disparity in Harvey Weinstein. The Harvey Weinstein case is an example of all of the stereotypes we encounter in discussions about sexual harassment. High earning, powerful, successful man whose behavior is tolerated because of his perceived value to the organization. And his bullying behavior was not only sexual in nature, it also included bullying male employees as well as clients and adversaries. The fact that this behavior was tolerated at Miramax should not come as a surprise, because the EEOC already knew that workplaces where there are significant power disparities are at risk for claims of harassment. The biggest lesson we can learn is that even though the victims are protected by the law, the reality is that speaking out against powerful people can come with serious personal and professional consequences. It's up to the business owners and supervisors to put a stop to these consequences and not let the perpetrator get away with the offense the first time. because if they get away with it the first time, they will repeat the behavior. So what do we do with all of these statistics and information from the EEOC? The EEOC suggests that the workplace culture has the greatest impact on allowing harassment to flourish, or conversely, in preventing harassment. The importance of leadership cannot be overstated. Effective harassment prevention efforts and a workplace culture in which harassment is not tolerated must start with and involve the highest level of management in the company. But a commitment to a diverse, inclusive, and respectful workplace is not enough. An organization must have systems in place that hold employees accountable for this expectation. Accountability systems must ensure that those who engage in harassment are held responsible in a meaningful, appropriate, and proportional manner, and that those whose job it is to prevent or respond to harassment should be rewarded for doing that job well or penalized for failing to do so. We cannot be complacent bystanders and expect our workplace cultures to change themselves. If your work culture needs improvement, don't just take your training today as an opportunity to check a box on your compliance list. Take steps to implement a campaign to improve your company culture. I like to think that the word character as applied to people is how you behave when no one is watching. Well, people with good character will behave well even when nobody's watching. So think of your company culture like your company character and establish policies that guide employees to know what to do when no one is watching. So we've had some cases in the news. If we take a close look at them, we can tie the risk factors from the EEOC back to these cases. I'd like to emphasize, however, that just because they are in the news doesn't mean that the accused parties are guilty. I'm not highlighting these stories with any bias toward or against either party. I'm simply using them as tools to point out the risk factors that these organizations are facing. So, our first one is Governor Cuomo, New York governor. So, Lindsey Boland, a candidate for Manhattan Borough President and former advisor to New York Governor Andrew Cuomo, in a tweet the week of December 7th, 2020, said in a tweet, "Yes, New York Governor Cuomo sexually harassed me for years. Many saw it and watched." So what happened? The governor's office denied the allegation. They used the denial fence. They responded by saying there is simply no truth to these claims. So they're using the denial defense. She responded by saying there are fewer things more scary than giving this man who exists without ethics even more control. Not knowing what to expect was the most upsetting part, aside from knowing that no one would do a damn thing even when they saw it. This is how she responded to his complaint of denial. But other New York state officials and employees have also been the subject of such reports in recent years. In 2017, for example, a former state employee reported that Sam Hoyt, who had recently resigned from his job as a senior level state official, had sexually harassed and assaulted her. Hoyt again denied the allegations, but said the two had a consensual relationship. So he is using the welcomeness defense. And in 2018, New York Attorney General Eric Schneiderman resigned after the New Yorker reported that 4 women had accused him of physical abuse. So Cuomo has bristled in the past when asked if the New York state government has a problem with harassment. He says, when you say it's state government, you do a disservice to women, with all due respect. It's not government, it's society. It's not just one person in one arena. So now he's leaning towards the reasonable person defense, that it's accepted by the reasonable person in society. So what types of risk factors would the EEOC identify with this organization? First of all, it's a workplace with high value employees. And second of all, it's a workplace with significant power disparities. So the EEOC would recommend applying workplace rules uniformly, regardless of rank or value to the employer. And if a high value employee is discharged for misconduct, consider publicizing that fact. And the EEOC also recommends paying attention to relations among and within work groups with significant power disparities. So I'm not saying that the EEOC's recommendations will work, but that's what the EEOC recommends in workplace environments where there are people with high value employees and workplaces with significant power disparities, which describes that situation. Our second one that was in the news as of December 8th, 2020, is that Secretary of the Army, Ryan McCarthy, is firing or suspending 14 Fort Hood commanders and other leaders, from top leaders down to the squad level. And this comes after the death of a female soldier at Fort Hood. After her death, her family raised allegations that before she was killed, she had been sexually harassed. This case was in the news because she went missing and they actually found her body. The Fort Hood Independent Review Committee reported that soldiers are concerned about the consequences of reporting harassment due to fear of retaliation. So Secretary of the Army Ryan McCarthy acknowledged that in many cases, commanders were responsible for setting a tone that was not consistent with the Army's core values regarding sexual harassment and harassment policies. So the risk factors that he's describing are exist in this organization are: number one, a homogeneous workforce. It's primarily men. It's also a workforce with significant power disparities. The military is based on rank, so there are significant power disparities just in the very nature of the organization. In this case, if you look back at McCarthy's statement, he said, commanders were responsible for setting a tone that was not consistent with the Army's core values. This indicates that it was a decentralized workplace, meaning that the top brass didn't really have an understanding of what was happening at that level of the organization. So what does the EEOC recommend for these three risk factors? The three risk factors are homogeneous workforce, workforce with significant power disparities, and decentralized workplaces. The EEOC recommendations would be increasing diversity at all levels of the workforce, with particular attention to work groups with low diversity. So the diversity is caused by not enough women in all levels of the organization, but probably also because there's not enough women in the upper echelons of the organization. The EEOC also recommends pay attention to relations among and within work groups, apply workplace rules uniformly, regardless of rank or value to the employer, and pay attention to relations among and within work groups with significant power disparities. When it comes to decentralized workplaces, the EEOC recommends ensuring that compliance training reaches all levels of the organization, regardless of how geographically dispersed workplaces may be. Ensure that compliance training for area managers includes their responsibility for sites under their jurisdiction, and develop systems for employees in geographically diverse locations to connect and communicate. So I'm not saying that any of these recommendations would have prevented what happened in Fort Hood, but I just wanted to use that as an example to identify the risk factors that the EEOC would identify and what the EEOC's recommendations would have been for those risk factors. So we started the whole workshop today, 2 hours ago almost, with a true-false questionnaire, and we are going to review what we've learned today by going through our true-false questionnaire again to see if we would answer any of these questions differently. So again, on your piece of paper or using your chat box, just go ahead and write your answers down or chat your answers to me, and we'll go through this before we wrap up today's presentation. So number 1, individuals can be personally liable for sexual harassment. Is that true or false? So that one is true. Individuals can be personally, financially liable for any judgments that come in a court case. All right, number 2, volunteers and unpaid interns are not protected against sexual harassment in California. Is that true or false? This one is false. They are protected in California, but only under state law, not under federal law. And remember, the IRS auditor is not protected. Number 3, sexual harassment only occurs if a female is harassed by a male boss. Is that true or false? This one is false. It's been settled law for some time that same-sex sexual harassment is actionable under the Fair Employment and Housing Act, the FEHA. And remember, it's the FEHA that is the California Act. Number 4, recent sexual desire is a key element to any claim for sexual harassment. Is that true or false? This one is false. 10 years ago, it would have been true. It's only recent legislation that clarified the existing law by expressly stating that sexually harassing conduct does not need to be motivated by sexual desire. It was Senate Bill 292 in California that was passed to repudiate a contrary decision in Kelly versus Conoco Companies that was decided in 2011. So it's just been within the last 10 years that this was overturned. Number 5, an employee can file a claim for sexual harassment even if the supervisor took no adverse employment action like termination, failure to hire, demotion, or anything else against the employee. Is that true or false? That one is true. Number 6, an employee can only file a harassment claim if they experienced economic loss or other adverse employment action. Is that true or false? This one is false. And remember, the crux of a harassment claim is the assault on the complainant's personal sense of dignity and well-being. In California, if the employee does not take advantage of the established internal complaint process, the employer has a complete defense to a sexual harassment lawsuit. Is that true or false? This one is false. It's a good defense, but it is not a complete defense. And our last one, California mirrors federal laws regarding harassment in the workplace. This one is false. California law and federal law differ regarding harassment in the workplace, but also California law and federal law differ based on the types of discrimination that there are. California recognizes 18 types of discrimination, while federal law only recognizes 8 types. So it's time for any final questions before we end our session today. Please feel free to use your questions or comments box, your chat box. And also, if you have any questions that come up, please feel free to email us at training@yourcompliancemanager.com, and we will get your questions answered within 1 business day. And just a reminder that a copy of this PowerPoint deck will be made available to the person who registered the participants of your company. And a certificate of completion will be emailed to both you and the person in your company that paid for your registration as proof of attendance today. If you are watching this video on YouTube, then please email your responses to me with the subject COC, and we will get your certificate of completion out within 1 business day. And the email to send that to is training@yourcompliancemanager.com, and we will get your certificate of completion out to you. So thank you to everyone that attended today. You are a great audience, and I look forward to another session with you in 2 years. Thanks.